In this light, the United Nations has recently come up with some proposed solutions. Mr. Rajat Bansal, a UN Tax Committee member and a senior IRS officer, has made significant contributions to these proposals, and hence they are hailed as the Bansal proposal. To talk on the merits of this UN solution and whether it is an acceptable alternate in light of the OECD unified approach, we have with us today the esteemed presence of Mr. Mukesh Butani. Mr. Butani is the founder and managing partner of BMR Legal Advocates, one of the leading tax law firms of India. He is a highly acknowledged international taxation expert and has to his credit several landmark judicial pronouncements. He has also deposed as an expert witness on contentious cross-border tax treaty and transfer pricing matters in foreign jurisdictions. In context of digital taxation, Mr. Bhutani was recently an observer at the UN Tax Committee meetings in his capacity as the Vice Chairman of the International Chamber of Commerce Taxation Commission. It is our thorough privilege, therefore, to have your insights on the theme today. Over to you, sir.
Good afternoon, or good morning rather, depending where you're joining from. In today's environment, you really don't know where people are joining from. And thank you, Kingshuk. I'm taking the liberty to call you by your first name and not Professor Jha, because we have been working together on a few projects. So firstly, thanks for inviting me. And I think it's an absolute pleasure to be speaking on this platform after a long time. The topic chosen is a tricky topic. It's tricky for a variety of reasons. I know that the Jindal Global Law School has tremendous commitment insofar as tax as a subject is concerned. In fact, there is an LLM in taxation in one of the few law schools that has an LLM in taxation. The other reason why this topic is tricky is because there is so much literature that's available with regard to the topic on digital taxation. And in my view, for the first time, taxation as a subject beyond the general principles of double tax treaty has assumed geopolitical connotations. Now, whether those connotations started in 2015 when the OECD G20-led BEPS 14 action points came into effect, or it started gaining momentum when action point 1 that dealt with digital taxation could not be taken to its logical conclusion given the complexity involved. Now, the focus is clearly not to talk about the OECD. The topic today is Bansal proposal an acceptable alternative in light of the unified OECD approach? We will not be doing enough justice to this topic if we don't set out the context. And as I had mentioned to you, the topic is deep, and the challenge for speakers like us is, given the limited time that we have, how well are we able to cover this such that we are able to convey the message that we want to with regard to this topic. So just to be able to set the context, in the first slide, I've just tried to lay down very fundamental digital business models. And I have deliberately chosen names that are virtually household names, just to be able to distinguish that all of these are different business models. Now, what are different business models? We all understand H&M, but we understand the H&M store. We don't understand how many products H&M is selling now through online system. And this is again assumed significance in light of pandemic. I have been given to understand that H&M's online sales globally, which were roughly around 15%, went up to 40% for obvious reasons. It is very much possible that as we all emerge from pandemic, this will continue. And it's also possible that H&M may want to relook at their business model and say, why do we want to have the brick and mortar store? Why not cut costs? Why not pass on those efficiencies to customers? So digital model is making sense. So that's H&M. Netflix, I don't need to tell you, online content, digitized content. But this online content that's available for us in India is not just about the content which is typically like a Hollywood movie. It's a content that comes from Latin America. It's a content that's made in India. Who would have thought 2 years back that Netflix will actually go into production? It will actually go into owning studios. So what you see as the final product, which is the digitized content, is what we as customers see. But it is resulting in a paradigm change in the business model of Netflix. Amazon, we all know, a marketplace. The reason I put this as a marketplace, and this is particularly relevant for India, is the FDI regulations do not permit foreign investment in a facility which is outside of the marketplace, which means that Amazon cannot have stores, Amazon cannot have fulfillment centers that it owns, it has to have a contract. So it is at best a marketplace model in India. Microsoft, we all are aware of the model, but this is not Microsoft, it's Microsoft Azure, which is providing infrastructure as a service on an online platform. And Facebook, which we all use, we love it. However, the business model of Facebook is to sell advertising space. So you see enterprises in this new digital ecosystem have certain characteristics. What are those characteristics? It's mobile. You rely on data. There is usage of multi-sided business models. There is change in the sense that there is volatility in the business. And the most important thing, it is agnostic to which jurisdiction it offers in. So Facebook has an office in India. All of them have a presence in India, but they could offer many of those services without having a presence in India. So these are now large enterprises whose presence in a jurisdiction do not matter. However, by ensuring that these activities are conducted through digital means where they can reach out to their customers, clearly leads an opportunity to avoid payment of what is called a fair share of tax in the market jurisdiction. So that's really the question before the lawmakers. Now, what are these issues? Clearly, one, let's look at on the left hand side, what are the features of a digital business? And then on the right hand side, what are the tax challenges that are arising out of these businesses? And the Bansal proposal tends or attempts to answer some of these questions. First, user participation is important. It's not where you provide the service from. It's not like a factory. It is where the customers are located. Two, scale without mass. Okay. Three, there is heavy reliance on technology and heavy reliance on intangibles. Now, these intangibles have to be given a contextual meaning, because intangibles in the context of tax is different than intangibles as we understand in the context of an intellectual property law. So when we talk about intellectual property law, we talk about patents, trademarks. But when we talk about intangibles in the context of digital business, these are not the ones that we deal with typically when we study IP laws. So what are these challenges? Nexus becomes a very important determinant. The current set of rules, insofar as Nexus is concerned, does not deal with digital businesses. So classic Article 5 and Article 7 that deal with permanent establishment and attribution of profits to permanent establishment really talked about a physical presence, a office, a place of management, a factory, a site, a fulfillment center. Now, digital businesses don't require that. So what is a nexus? Is the participation of customer a nexus? Is the frequent participation of customer a nexus? Is there a threshold in terms of number of customers we want to fulfill that criteria? That depends from situation to situation. Data is very important, because the data that gets collected is attributable to creating a value for the organization. Whether that value is built up over a period of time, or that value is something that is monetizable in the future, interplay of data is very important. And last but not the least, characterization. Now, the debate on characterization is not new to digital forms of businesses. We knew that this characterization debate is there. So when a service is provided, should it be characterized as royalties or fees for technical services, often called as passive forms of income, or should it be active income, which is a business income? Because the taxation varies depending on the characterization. For the former, the taxation is on a gross income basis, and for the latter, it's on a net income basis. Now, I don't want to necessarily get into issues, but those of you who are interested, this is a very lively debate in India. People often ask question, why is India at the thick and thin of the digital tax debate? Well, number one reason, market jurisdiction is in India. You know, imagine 20% of people who surf through Google are Indians. Imagine one third of people who have Facebook accounts are Indians. So that's one part of it. Second part of it, the debate is very much alive in our country. If you look at important cases such as the advance ruling decision of MasterCard, which is before the Delhi High Court, very clearly says that certain automated forms of businesses where a foreign enterprise is running through a server and carrying on its core business activity, which does not entail human intervention, will constitute a permanent establishment. Similarly, the Bangalore Tribunal, again an order which has been stayed by the Karnataka High Court, held that the payments that are made by Google India to Google's Irish entity for what is called an AdWords space, which is basically the brain of Google, should be characterized as fees for technical services. And the tribunal made some very important observations in terms of this is not just a service, but this is a use of an intangible, and therefore it should be in the nature of royalty and not business income. So this is a live debate, whether it's a MasterCard case before the Delhi High Court or it is the Google case before the Karnataka High Court. And I have no doubt in my mind that this will get even more interesting debate as they travel to the Supreme Court. So migration from FAR to FARM. Why is FAR important? What is FAR? Functions, assets, and risks. That's no longer the first principle for transfer pricing. It's functions, assets, risks, and markets, which is a market jurisdiction. And this is very important because this forms the core and the first principle of source-based taxation. India has been at the forefront of this debate, not just for the purposes of digital taxation models, but also for the purposes of other forms of business models wherein market plays a very important role. And hence, even for the purposes of application of arm's length principle, the market analysis assumes significant and go beyond the function, assets, and risks. And finally, what are these factors which allow businesses to access markets, particularly in a digitized economy? The concept of markets actually is not just focused on action point 1, which deals with digital taxation of the OECD, or for that matter, 12B, what we are discussing today, but it is also important from the point of view of action point 8 to 10 and 13, which deals with transfer pricing. And essentially, action point 8 to 10 attempts to sharpen the transfer pricing principles or the arm's length or the application of the arm's length principle with a renewed focus called value creation. That there are certain forms of intangibles that are value accretive, that create a value for the organization. And those are the ones that have been recognized in action point 8 to 10 and now assume even stronger consideration, particularly if you look at the demand side factors in a growth and developing emerging economies such as India. While this debate is immediately relevant in the context of digital taxation, the fundamental principles remain that FAR versus farm analysis is relevant in the context of transfer pricing. So before we get on to Article 12B and why Article 12B arose, let's look at what is the unified OECD approach. I'm not going to get into the history. I started off by saying 2015, action point 1 was delivered. on digital taxation. Clearly, if you read action point 1, it is suggestive of divergent views that nations have been having. To a larger extent, in the last 5 years, that those divergent views have got even more muddied. And what do we have now by way of proposals? So let's look at the latest proposal. The latest proposal is a blueprint on action point 1, action point 2, which are also called GLOBE proposals. What do they tend to achieve? They tend to achieve what is called a consensus-based approach in mid-2021, what was supposed to be happening in the end of 2021. However, as a result of political developments, particularly with respect to the participation of United States, which is a major partner, the negotiations have been delayed, and now there is a new deadline that has been set up for mid 2021. The proposal essentially has introduced Pillar 1, two forms of profit allocation mechanism. It's, for the sake of argument, it's called Amount A and Amount B. Before the proposals were synthesized into what is called as a blueprint, there was Amount A, Amount B, Amount C. Let's not get into that debate, but what we have today is Amount A and Amount B. Amount A is nothing but a portion of the deemed residual profit of the global organization being allocated to the market jurisdiction using a formula. That formula is complex, that formula is debatable, and we haven't gone into the fine print of that formula. This particular amount A is labeled as the new taxing right. Then we have amount B. Amount B is nothing but the fixed remuneration for distribution activities, also called marketing and distribution functions, that take place in the market jurisdiction, which is the classic arm's length approach, the vanilla approach that we currently have. So amount A is critical over here. All the debate in the blueprint is surrounding amount A. Now, there are few thresholds that have been put in place to avoid unnecessary complication insofar as amount A are concerned. The threshold for gross revenues, what should it apply on? What should be the gross revenues of a global organization? The other the other threshold is the aggregate in scope revenue. What is this revenue that needs to be considered for the purposes of determining the deemed residual profit of a multinational enterprise? And 3 is the de minimis amounts. So this is, in summary, pillar 1. What is pillar 2? Pillar 2 is fairly different than pillar 1. It is not an alternative to pillar 1. It's a proposal that's driven by countries that have either high technology and R&D in specified digital businesses, or who have high degree of anti-abuse provisions in the domestic law. But it is an alternative way to be able to levy tax on a business which is a digital business, but the focus moves from the market jurisdiction to the residence jurisdiction. The 4 components of Pillar 2 proposals, very briefly, are income inclusion rule, the rule for untaxed payments, the rule which is called the switchover rule, and the 4th is the subject to tax rule. All of these are figuring in some shape and in some form in the domestic legislations of France, Germany, but more so in United States. So people who are familiar with the Jobs Act of December 2018, the guilty proposals, the beat proposals, those are all encompassing what is proposed as Pillar 2 proposals under the 4 components that I spoke about. So this essentially is the proposal. It's broad-based, the concept of value creation, and more importantly, the transfer pricing principles enshrined in Article 8 to 10 are to a larger extent diluted, because amount A is not an arm's length outcome. It is amount B, which is a arm's length outcome. it is possible that amount A and amount B, which are the new taxing rights for the market jurisdiction, could result in, depending on the profitability and the customer base of a multinational organization, actually allocating more profits to amount A than to amount B. So to a larger extent, it dilutes what is a conventional principle of arm's length philosophy. Now, how is the UN proposal different? First of all, to some extent, from perception standpoint, the UN proposal is not completely understood. First of all, it is not in any manner attempting to reinvent the wheel. It is merely trying to simplify. It is merely trying to give an alternative just in case pillar one, pillar two do not succeed. The probability of the world adopting pillar two is less because it suits only few countries. So pillar one is really the credible alternative under the OECD BEPS project. Should pillar one fail, and the chances of that somewhere in the month of July and August, as a result of US withdrawing from the discussion, the US Trade Commissioner initiating what is called Action 301 against certain 7 countries, including India, did tend to convey a complete destability of the OECD proposals. And that's where UN proposal gathered momentum. Though the UN proposal, which is popularly called Article 12B, the Bansal proposal, was in the works for a while, but it actually emerged into prominence only in August, September, when it was made public, and we could see considerable shaking up of the foundation of Pillar 1. The UN drafting group, thereafter, it's a 13-member drafting group, took on themselves in their personal capacity, and I'm using the word personal capacity because the way the 25-member UN committee works is that all the members, who though majority of them would be representing the respective governments, but they represent in their personal capacity. And that's why this drafting group of 13 members out of the 25-member group wanted to look at a solution for developing countries. Now, the UN group is ring fencing the digital economy, first of all, and it has been tasked with specific issue to deal only with aspects arising out of the digital economy. Now, how is it ring fencing? Well, it's ring fencing, and we'll look at it later on, because it is dealing with a category of business called automated digital services business, which is different from the OECD BEPS proposal, which is dealing with consumer facing businesses. Now, you can have an automated digital services business, which is also consumer services business, but the definition and the depth of coverage that you have in the OECD proposals are far more deeper than the UN proposals. Two, simplicity is paramount to United Nations, because under the UN Article 12B proposal, because you're not just dealing with large developing economies or emerging economies where the markets are very large, but you're also dealing with fairly underdeveloped or economies which may not be as big as India, but the level of sophistication of the tax administration or the mechanisms for resolution of disputes under the administrative courts or the experiences of those countries insofar as the functioning of the competent authority is concerned for resolution of double taxation is limited. So you're really dealing, that's where the principle of simplicity comes in. Now, what this Article 12B proposal says as an alternative to what we spoke about is that the automated digital services will pay tax in either of the model. Now, this is where the complexity arises, and this is where we are attempting to answer this question: are Bansal proposals a credible alternative? So let's look at it. First option, a withholding tax on gross income. Okay, and this withholding tax has to be negotiated through a bilateral treaty process. So India and US, if they adapt Article 12B in the tax treaty, they will negotiate a withholding tax rate. And for the purposes of this presentation, we have taken that hypothetical as a 2% tax rate. Or A qualified profits of digital taxation will be taxed pursuant to an appropriate formula. Now let's try and look at what is this appropriate formula. First of all, under this proposal, it really does not matter whether the services are provided in the payer's home state or it is provided elsewhere. It essentially talks about the same strategy that UN adopted when it formulated Article 12A. What is Article 12A? Technical services. If you go back into the OECD model, technical services is not mentioned over there. The most important part of passive income in this category is royalty. United Nations discovered, and India played a very significant role in it, to come out with Article 12A, where technical services are important. So it doesn't matter where the technical services are provided from. What matters is where it is consumed and where it is used. And if that usage is occurring in a particular country, that becomes the source country. A similar principle has been now deployed in the context of Article 12B invention. Where are the customers located? If your customers are located, that becomes your source country. So that's a very important fundamental principle. Then comes the determination and tracking of liabilities, which could be a tricky, particularly when you're dealing with a B2C model. And more importantly, the draft proposal also acknowledges that financial intermediaries could remit the tax on an approach which is a recognized approach under VAT. Now let's try and look at it in the Indian context. In the Indian context, we have a class called OADR services under GST, wherein the service provider is offshore, the service recipient is in India, the service recipient pays the GST on what is called as a reverse charge mechanism. You're really implanting the same principle now insofar as levy of withholding tax, option one, that we discussed in the earlier slide is concerned, where we are saying that withholding tax mechanism is easy to track it. Now it encompasses both B2B and B2C automated digital model because the automated digital service is agnostic to B2B and B2C. However, more importantly, and from a practical standpoint, if you look at a B2C services, the withholding tax obligation is very difficult to enforce. Just imagine that you are getting you're paying a subscription for a digital service and you are made responsible for withholding tax. Even practically, we know that when a business pays rent or a business makes contractual payment, you can withhold tax. But when an individual does it, he doesn't have a withholding liability. And because the customer is most important, the B2C is a very complex digital model in order to be able to implement the withholding tax mechanism. So very briefly to summarize, very basic comparison between Pillar 1 and Article 12B. 1, in terms of coverage of business, as I had mentioned, 12B does not cover consumer services business. 2, in terms of options, Pillar 1 does not envisage a gross basis of taxation. Pillar 2 does envisage. The withholding tax option is a gross basis of taxation. And that's also the final tax. It's not a withholding tax, but it's a withholding and a final tax. No different than what we have today in the context of equalization levy, except equalization levy is not creditable and there are other forms of challenges associated with it. Minimum threshold, Pillar 1 does go to prescribe, not as yet, but it is enshrined in the scheme that there would be a threshold. Article 12B does not envisage that. So you could have a foreign company that's providing automated digital services. Should Article 12B be adopted, there are no threshold. So even if the value is very small, say $1 million, it could get covered. Now, many of these thresholds would have to be laid down bilaterally on a country-to-country basis. And since many of the UN members from the developing economy have a very low tax base, they may not want to set out a higher threshold. So that's a debatable point that remains. Clearly, the implementation of Pillar 1 is through a multilateral instrument, no different than how minimum standards on principal purpose test and dispute resolution was implemented through an instrument called a MLI, multilateral instrument. The implementation for a UN is only through the bilateral route. So it will be there in the UN model, and it's up to the countries as a part of their treaty negotiation process to adapt Article 12B as a alternative to digital taxation. Some discussion points that merit consideration in the context of UN proposal include it's simpler, it's workable, however, it sacrifices on a very important principle that has been laid down itself by the OECD on value creation. More importantly, the concept of taxing an income has a very fundamental core principle to it, that though you're taxing income, you're actually taxing profits. So by levying tax on gross basis and by not getting into the determination of actual profits, it defeats the fundamental principle. It may allow a satisfying outcome for market jurisdiction, but it could subject private stakeholders to excessive or double taxation. There are mechanisms under Article 12B to be able to resolve it through double taxation. However, there may be a situation where the market jurisdiction levies tax because it has acquired right under the treaty. However, you may either not get a corresponding credit in the home country, or the home country may again want to tax that income. So that's the complexity part of it. It clearly faces stronger resistance from US as a jurisdiction because US again has gone beyond Pillar 1 and is opting for Pillar 2. So there are challenges. However, clearly the emerging economies voice is being heard in the UN committee, and we need to see how the UN committee deals with this proposal, because in the April meeting of 2021, this is likely to come up for debate even further. Automated digital services, clearly ring fencing principle that I spoke about, and it is clearly an easier avenue for market jurisdictions to levy tax. However, consumer facing businesses and automated businesses are not mutually exclusive. And we have given Uber as an example of that situation. Very quickly, just a quick case study before we get into the Q&A. This is a case which kind of compares 12B2 and 12B3, 2 and 3 being alternatives to taxation. One is the withholding tax, and second is a tax on certain forms of activity and the application of the tax rate, how it works. So here we are dealing with company X, which is a resident of Germany, providing digital services to in India. It could be a B2B or a B2C. The German company does not have a permanent establishment in India. It receives an annual gross revenue of 1,000, and it clearly falls in the category of automated digital services. The global profitability of company X is 1/5, so 20%. So everything which is there in the top line, 20% is the global profitability ratio. Now, Article 12B of the India-German Treaty, if adopted as agreed to in the draft between OECD, insofar as Article 12B2 is concerned, it's very simple, 2% withholding tax, that's an assumed mutually negotiated rate that will have to be paid. This will have to be paid on the revenue it earns from India. What does it earn from India? It earns from India a revenue of 100, which is attributable to revenues earned from Indian customers. Now, the domestic tax rate in India is 25%. On the face of it, it seems beneficial because the German company's net net profitability is 20%. Now, 12B, what does 12B actually say? That since India is a tax source jurisdiction, 12B gives a right or option rather to X either to be taxed in the source jurisdiction under 12B2 or under 12B3. So let's look at what those choices are. Choice 1, India-German treaty provides for a withholding tax rate of 2%. And since the gross revenues received from India is is on 100, India may be able to tax 2%. Under Article 12B3, if this company exercises to be taxed on the qualified profits, not on a withholding tax mechanism, then the qualified profits percentage of tax will be compared. So there will be a 30% tax rate on the gross annual revenue divided by the percentage of profitability. So let's assume the profitability here is 20%. So what would be the profit on 100 would be 20, and then you'll apply a rate of 30% tax on 20. So that's how it will pan out in terms of both options, very, very simplistically stated. Now, where do we stand in terms of the challenge, and how do we see these proposals getting accepted, and how palatable are they? Clearly, on one hand, lies the challenge for emerging economies, particularly India, to collect their fair share of taxes. And on the other hand, we also need to factor in that there are certain amendments that have already been effectuated in the domestic law in pursuance to action point 1. One is the significant economic presence test, which was legislated in the 2018 budget. It could not be put into force, and we will try and just look at why it could not be put into force as a result of the public consultation paper of April 2019. But in the 2020 budget, the scope of significant economic presence has been expanded, and now it is proposed that it will be put into force from April 1, 2021. Now, a significant economic presence is housed in the business connection rule of the Income Tax Act. However, when you're dealing with a treaty partner, you tend not to look at the business connection rule, you look at the classic Article 5. So up until the tax treaties are amended under Article 5 through a bilateral or a multilateral mechanism, significant economic presence is of academic value, particularly to the treaty partners. But technically speaking, it can apply to a non-treaty partner. Then we have the proponents of Article 12B that we discussed about. And then next year, we will see some form of global consensus. And with the change in the US administration, the hopes and the expectation of a global consensus has clearly gone up in the past few weeks. Where do we see as India's roadmap to digitization? It started off with the first committee that proposed the concept of equalization levy on a host of services. India was amongst the first country to legislate equalization levy in 2016 budget, but covering only specified B2B services, that too in the digital advertising space. And then there was a pause, but there was a pause from the point of view of expansion of the equalization levy. But there were amendments that were undertaken to the erstwhile GST law and then the GST law in 2017 to tax under OA or OIDAR under the reverse charge mechanism. This is for services that were consumed in India. 2018, as I mentioned, saw the legislation of the significant economic presence, followed by a public consultation paper. And the public consultation paper, though had lots of comments, but it was deferred in anticipation of the global consensus. In 2020, we saw a considerable expansion of the equalization levy, and this levy now moves from the recipient of services to the provider of services. and many changes and amendments were undertaken to the income tax statute. But since equalization levy is not today's topic, we are not going to focus on that. Last but not the least, very quickly, where do we now go insofar as the arm's length principle is concerned? I spoke about it earlier and said arm's length principle to a greater extent has got diluted in the OECD proposal itself, where amount A is dealing with the new taxing right, and it's only amount B that deals with the arm's length principle. And hence, a formulatory approach is being evolved. So the taxation of digitized businesses is becoming more and more complex. Clearly, there is no one size fit all solution. An industry specific profit attribution approach will have to necessarily rely, in our view, on the arm's length principle as the basic tenet, and instead supplement it with a formula which is perhaps a solution on a go forward basis. From a futuristic standpoint, countries will have to withdraw unilateral measures such as equalization levy of India, because though they serve as an interim quick fix, they do not offer long-term solutions besides the risk of double taxation. And India is a pioneering example when it comes to enactment of equalization levy as well as significant economic presence. But what will be critical for India would be the need to align itself as much as possible, its domestic law provisions with the ongoing discussions at the global level, because that, in our view, is the future long-term goal. We should bear in mind that we have an extremely ambitious digital agenda as a part of the larger public policy. And if that be the case, we have to be mindful of the fact that any additional tax that we impose accompanies with itself simplistic compliance requirement, and the regulations are clear and unambiguous, which is not the case insofar as the equalization levy expansions stands as a result of the 2020 budget amendments. Neither have we come out with any policy that, given that the significant economic presence is there in the law, its implementation has been deferred to April 1, 2021. What's going to happen on that April? Well, we could possibly see answers to some of those questions in the budget that we are going to see within few weeks from now. So with that, Kingshuk, over to you. And I'm very happy to take questions. But as I'd mentioned, Kingshuk, I have to sign off at 5:55, 5:56, because I have a, sorry, 4:55, because I have a session starting immediately thereafter. Thank you.
Definitely, we understand your time constraint, but still, thank you so much for taking out time and presenting with us this with this lucid overview of a very complex situation which we are facing at the moment. So, on this note, I would really request the attendees to pose any questions if they might have. In the meanwhile, while I suppose the attendees would be keying in their questions in the chat box, I would like to have a question for you, Mukesh. If possible, please allow me to ask it. Uh,
Please.
this is to do with the fact that the consensus-based solution which we are trying to achieve, especially at the OECD level, is it possible to have this sort of I would say, resolution where different economies, and particularly the market economies, which are developing countries, and the residence-based economies where the companies are actually, the digital companies are actually located, is it possible to have such a consensus when they have different sort of political agendas?
Well, I mean, it is a challenge in the sense that when there are different political agendas, you know, you are making competing ends meet over here. I think it will be very speculative on our part to presume what is the future and how these conflicts are going to be resolved. But I think what is coming out very clearly in my view is that the market jurisdictions have clearly been able to establish that there is a credible uh, way that taxation can be achieved outside of the first principles of international tax. So let me just go back before the BEPS discussion started. I don't think that, given the commitment which is there under the double tax treaty, which talks about the traditional rules of taxation, there was basis for any country to tax digital income, particularly if you do not have a presence in India. uh, I think so there are two things that have happened in the last 5 years. Should we tax digital income? The debate is no longer whether we should tax digital income or not. The debate is, yes, we should tax digital income. And the debate is now stuck into how should we tax business income and how should we allocate the taxing rights. We have even gone a little bit further on that debate and said one of the important principles of taxation will be giving right to the market jurisdiction, which is called the new taxing right. Clearly, I mean, where we are stuck, if you look at the blueprint, is some of these nuances, how to tax that income, and that is becoming very, very important. A consensus will need to be arrived at, and in the pursuit of consensus, there has to be a balance struck between what used to be residence and source versus resident, source, and market. So what has happened is that the friction between residence and source countries was always there. And I gave an example of Article 12A on fees for technical services. OECD models were opposed to the concept of FTS, but UN went ahead. But now we have a third variable, which is the market jurisdiction. What is more critical in my view is the tax certainty part of it for business, because businesses do not want double taxation. And if in the event there is a double taxation, then there has to be a basis to be able to resolve that double taxation. And that is where country specific policies come into play. For example, action point 14 that talks about mandatory arbitration, India has not embraced that for the reasons that adjudication of tax dispute is a sovereign function, and that they would not resort to mandatory arbitration more as a public policy stance. So those are then the areas of friction which in my view cause a debate. And hence, um, you know, resolution of tax disputes, will have to be prevented or mitigated, if I may say so, based on the digital taxation models. But again, there is no one size fits all approach. Industry specific profit attribution approaches will have to be agreed upon. And in my view, arm's length principle should be the basic tenet, and we should not give up on the arm's length principle so fast. So it's not going to be an easy situation. It is going to entail fair bit of work to achieve the consensus. But I feel that the blueprint document has zeroed down, or has narrowed down rather, what are these areas of friction that needs to be addressed on a go forward basis to minimize the friction.
Thank you. Thank you for that detailed answer, and seems to be quite promising the way we have, the solutions lined up as of now. And of course, the solutions are being worked upon. There are deliberations which are going on. But then uh, I think a attendee just now posed a similar question, that won't bilateral treaties allow aggressive political negotiations, which might place developing countries at a disadvantage? So I believe more or less you have answered this in the previous questions.
Let me just take this specific question, Kingshu. It's a very interesting question. Well, any bilateral convention negotiation, it does matter what kind of political clout, economic clout a particular country has. So, insofar as India's ability 10 years back, 20 years back on an international convention is concerned, that ability has certainly got enhanced, because India assumes now center stage in all forms of negotiations, whether it is India's withdrawal from the RCEP or India's view on climate, also the pivotal role that India played in the BEPS project. So clearly, as the nation progresses and becomes a stronger economic force to be reckoned with, its ability to negotiate is very high. However, if this question is specifically in the context of bilateral treaties, insofar as digital taxation is concerned, um, when treaty negotiators sit on a negotiation table and the negotiations assume political connotations, then tax is not the only subject on the table. It could be anything. It could be environment, climate, trade, movement of people, comprehensive economic agreement, so, and that depends from country to country. So I have no doubt in my mind that given the heated debate that we have on digital taxation, if India was supposed to negotiate Article 12B bilaterally, then besides the respective, political, muscle of the countries that are sitting on the negotiation table, you would really put everything on the table. It's like, take an example of India, US. If India was supposed to discuss Article 12B with the United States, it won't be in isolation. There would be trade issues, there would be other forms of strategic, military issues that would come up. So this discussion, in other words, certainly is going to assume more political connotations ever before, which tax as a subject was isolated.
All right. That's definitely going to be something which we need to watch for. And the last question, given the time constraint which you are facing, Mr. Bhutani, the last question for the day which we can pick up is, and this is something which I've come across during my teachings in law school as well, is by a student named Adil Khan. He says, how to value data in a digital economy.
Adil, if you have a basis, please educate me on that. Well, I think, philosophically speaking, people say data is the new oil, so on and so forth. But I have a slightly different view on data. Uh, when you talk about data in the context of tax and not in the context of, localization of data or data privacy issues, which are different topics of debate altogether, until and unless you can attribute a value on a futuristic basis, and until and unless that event of monetization of that data takes place, you really cannot tax data. So you can sit and value data today, but will you be able to do it? The value of the data, purely from a tax point of view, will be determined when you start monetizing it. Otherwise, right now, you're hypothesizing the value of the data. So there are many, many research papers available where economists and transfer pricing experts are talking about how do you value a data. My view is that before you get to value a data, you will have to figure out, is there a value creation? If it is a value creation, when will that value creation occur? And when will the actual monetization occur? Because the trigger to levy tax is not when the income is hypothetical, but when the income is realizable.
Wonderful. I hope that answers your query to some extent, Adil. And you can definitely probe a bit more and revert to Mr. Bhutani as well as me when we have solution to this, question that how exactly to value data. So on that note, I would request my colleague, Ms. Dhwani Menkar, to present the vote of thanks. And from my side, again, thank you so much, Mr. Bhutani, for joining today's session. And over to Dhwani now. Thank you.
On behalf of the Center for Comparative and International Taxation at Jindal Global Law School, I'd like to extend a heartfelt gratitude to you, sir, for sparing out time of your busy schedule and enriching us with such an enlightening session. Thank you so much. In fact, we look forward to having such Jindal BMR joint projects in the future, akin to your associations to European universities. And we look forward to hosting you very soon on campus to carry forward such interesting discussions on digital taxation. This vote of thanks would not be complete without thanking Professor Kinshuk Jha for his invaluable support and guidance and for making this event possible. I would also like to thank Team BMR and Sumer Ahuja for his relentless support, the IT team for the technical support, and last but not the least, all the participants for your hearty participation and making this event possible. Thank you so much. Thanks a lot.
Thank you, Dhwani. I can take the liberty of calling you by your first name.
Definitely, sir.
Who are not aware of it, Dhwani helped me review a chapter for my transfer pricing treaties. Thank you very much. And thanks for acknowledging Sumer, which I would have done because this session was produced and directed both by him. I'm just the actor over here. And look forward to BMR Jindal partnership, more importantly on the project that we are currently working at. And yes, of course, more importantly, a visit to the campus is certainly irreplaceable, and this is a poor substitute. But I nevertheless enjoyed the session. Good luck to all of you